Welcome to CM Guide podcast series. Today, we're embarking on a deep dive into something absolutely fundamental to, well, every construction project, yet often surprisingly opaque. The world of construction contracts. If you've ever touched a building site, whether you're the property owner envisioning a dream project, maybe the general contractor juggling dozens of moving parts, or perhaps a specialized subcontractor laying the groundwork, you know the inherent challenges. We're talking about those silent stressors that can turn a meticulously planned project into a financial and logistical nightmare. Things like delayed payments, outright non-payment, and, the inevitable disputes that can halt progress, fray relationships, and really throw everyone's financial stability into question. So our mission for this deep dive is pretty straightforward. We're here to cut through the complexity and demystify the recent legislative changes sweeping across Canada. Our focus today is specifically on prompt payment and statutory adjudication. We'll unpack what these new laws mean for you, how they're actively transforming the entire construction industry, and, well, ultimately give you a true shortcut to being well-informed on these vital legal developments. Expect some surprising facts, real-world practical insights, and maybe even an aha moment or two along the way. So let's begin by painting the bigger picture. Why are these new laws even on Canada's legislative agenda? What deep-seated problems are they designed to fix? When you step back and consider it, the construction and infrastructure sectors aren't just about erecting buildings, they are colossal engines driving the Canadian economy. They contribute a truly significant portion to our gross domestic product and provide livelihoods for millions. So when things go sideways on a project, when a dispute erupts over payment or a critical delay pushes timelines, those disruptions don't just affect that one job site. They create these far-reaching ripple effects, threatening cash flow, jobs, and the stability of businesses all the way up and down the supply chain. It's a systemic issue, really, that impacts much more than just the immediate parties.
You've hit on the core issue perfectly there. These laws are a direct response to a deeply ingrained problem statement within the Canadian construction industry. For far too long, construction projects, particularly here in Canada, have been plagued by, well, a predictable set of conflicts. The most pervasive and arguably the most damaging has always been payment. We've seen persistent issues with delays, or worse, outright non-payment to contractors and subcontractors. Then there's the labyrinthine complexity around managing holdbacks, set-offs, and various lien claims. These cash flow disruptions aren't just inconvenient for many businesses, especially the smaller firms or, new subcontractors trying to establish themselves. They can be absolutely devastating. Imagine a small family-run electrical company completing a significant portion of work only to wait months, sometimes honestly over a year, for payment. That's not just poor business. It could be a death knell for them.
A death knell, absolutely. You hear those stories all the time.
Exactly. And beyond payment, delays are another huge source of friction. These can stem from major shifts in project completion timelines, sure, but also from seemingly minor yet equally impactful issues like delays in material delivery. Think about a crucial, custom-fabricated steel component not arriving on time. Suddenly, an entire phase of work impacting dozens of trades just grinds to a halt. The costs of idling equipment and crews and that domino effect on subsequent work can skyrocket.
Yeah, the ripple effect.
Precisely. And then we frequently see design disputes. These might involve a conflict over whether the constructed project truly matches the planned design or serious issues related to, say, the subpar quality of the completed work, often requiring extensive rework and causing more delays and costs. But the real aha moment that spurred these new laws, I think, lies in how these disputes were traditionally resolved, or more accurately, not resolved efficiently. Historically, the primary recourse for many of these issues was protracted, incredibly costly litigation or arbitration. We're talking years, not months, to get a decision, draining resources, and forcing companies into financial distress while they waited.
Just bleeding money.
Exactly. And while traditional alternative dispute resolution methods like negotiation and mediation were often encouraged in contracts, they weren't always sufficient. They certainly couldn't address the immediate cash flow problems that could literally bankrupt a company while a dispute dragged on. So these new legislative frameworks are specifically designed to fill that crucial gap. Their aim is twofold. First, to ensure that money keeps flowing through the construction pyramid, and second, that disputes are addressed swiftly without always having to resort to the full, often agonizing court process. It's a bold move towards ensuring financial stability and ideally fostering a less adversarial industry.
So it's really about keeping the wheels turning, financially speaking.
That's the crux of it. And it's also important to underscore that while this is a significant and relatively new development for Canada, the concepts themselves, prompt payment and statutory adjudication, aren't novel globally. They've been successfully implemented and proven effective in jurisdictions like the United Kingdom and most of the United States for many years now. So Canada isn't exactly reinventing the wheel here. We're essentially adopting a proven model. The long-term experience of these other jurisdictions provided Canada with a clear roadmap, really, for how to modernize our construction industry's legal landscape, moving away from a system that, let's be honest, often favored larger players or those with deeper pockets who could weather those extended payment delays.
That's a crucial piece of context, isn't it? Knowing that this isn't some untried experiment really solidifies why Canada is making this significant shift. So let's zoom in on the first major pillar of these reforms, the one that touches everyone's bottom line, prompt payment. When we talk about prompt payment, what exactly does that mean for your cash flow, and how does it fundamentally change how you get paid or pay others on a project?
Right. At its heart, prompt payment legislation establishes statutory non-negotiable deadlines for paying contractors and subcontractors for the labor, services, and materials they've supplied to construction projects. It's about legislating, quite literally, timely cash flow. The entire system is effectively triggered by what's termed a proper invoice. And this isn't just any bill or request for payment, it's a very specific written document that must meet certain detailed requirements for it to legally start the clock on these critical payment timelines.
Okay, so the proper invoice is key. What makes an invoice proper then under these new rules?
Well, it needs to be a written bill, obviously. And it must include the contractor's name and business address, the specific date of the invoice, and the period it covers. Pretty standard stuff so far. You also need information identifying the authority for the work, things like a contract number or a clear project name. It has to have a clear description and, if applicable, the quantity of the materials or services provided, the exact amount payable, and the payment terms. Now, here's a detail that often trips people up, actually. It must include the name, title, phone number, and mailing address of the person to whom payment is to be sent.
The specific person, not just the company.
Exactly. The specific person. And unless the contract explicitly states otherwise, these proper invoices must be given monthly or at least every 31 days. These requirements, while they sound simple on paper, can create unexpected challenges in practice.
I can absolutely see that. That particular detail about needing the name of the person to whom payment is to be made, I imagine that's a surprising practical wrinkle that often trips people up. How does that kind of specific, maybe even overly rigid requirement impact actual adherence to the prompt payment rules in the real world?
You've hit on one of the classic friction points right out of the gate. It's almost counterintuitive, isn't it? For many large organizations, payments are processed through departments like accounts payable, not individual named people. So if an invoice doesn't precisely meet every single one of these requirements, it can technically be deemed improper by the recipient. And what does that do? It effectively delays the entire payment clock from starting.
Ah, so it gives them an excuse to delay, even if the work is fine.
Potentially, yes. The specific detail of needing the name of the person, as you noted, is exceedingly rare in practice for many invoices and can inadvertently render almost every submitted invoice improper from a strict legal standpoint through no real fault of the contractor performing the work. This can lead to unnecessary disputes about the validity of the invoice itself, rather than the underlying work, which completely misses the spirit of prompt payment. While the intent is clarity, such a rigid requirement can undeniably be a bottleneck. On the bright side, some provinces, like Ontario and Alberta, have recognized this practical challenge. They have provisions that do not require prior owner agreement for invoice revisions, which offers a bit more flexibility for contractors to correct minor omissions without completely restarting the clock. So there's some pragmatism creeping in.
Okay, that's good to know.
Now, here's a crucial takeaway, a really significant shift. Prompt payment legislation invalidates conditional payment clauses. This is a massive change from how things used to operate. Clauses like pay when paid or pay if paid, where a contractor's obligation to pay a subcontractor was conditional on that contractor first receiving payment from, say, the owner, or even on the simple availability of funds, those are now legally void. They have no legal effect whatsoever.
Wow, so no more passing the buck down the chain if the owner's slow to pay.
Exactly. You can no longer legally tie a subcontractor's payment to the timing of your own upstream payment. This rule is designed to prevent cash flow from getting arbitrarily held up further down the supply chain. It ensures that the risk of upstream non-payment doesn't solely burden the lower tiers. It forces the party immediately above to take responsibility for ensuring payment flows down.
That feels like a fundamental shift in risk allocation.
It absolutely is. And the core of the prompt payment system truly lies in its cascading payment timelines. This is where the magic, or rather, the strict legislative discipline happens. It emphasizes continuous cash flow down the entire construction pyramid. It works like a chain reaction, which is its brilliance. Day zero is when a proper invoice is delivered by the contractor to the owner. Then the owner is legally obligated to pay the contractor in full within 28 days of receiving that proper invoice, unless they issue a notice of non-payment, which we'll get to.
The 28 days, okay.
Then, if the contractor receives full payment from the owner, they must then pay their subcontractors, specifically those whose invoices were included in that proper invoice, within 7 days of receiving payment.
Just 7 days, that's quick.
Very quick. And this strict chain reaction continues down to subsequent tiers. Those subcontractors must then pay their subcontractors within 7 days of receiving their payment. This structured approach is designed to prevent payment bottlenecks and ensure money circulates efficiently and predictably through the entire construction pyramid, like clockwork, hopefully.
It sounds very structured, very prescriptive.
It has to be to work. So what's the enforcement mechanism if payment isn't made according to these strict timelines? The legislation provides specific notices of non-payment and potent remedies. If a party isn't going to pay the full amount of a proper invoice, they must issue a written notice of non-payment or dispute within a specified time. For owners, it's typically 14 days from receiving the invoice. And this notice isn't just a casual email. It must clearly detail the specific disputed amount and the precise reasons for the dispute. Vague reasons won't cut it. Importantly, and this is key to maintaining cash flow, the undisputed amount must still be paid by the deadline. You can't hold back the whole payment just because you dispute 10% of it.
Okay, so partial payment is mandatory for the undisputed part.
Correct. If payments are delayed beyond these specified periods, unpaid amounts automatically accrue mandatory interest. This interest is charged at either the contract rate or a statutory rate, whichever is greater. It serves as both a financial penalty for late payment and a strong incentive for timely compliance. And critically, failure to comply with these prompt payment rules also grants the unpaid party an immediate right to initiate statutory adjudication, which brings us directly to our next big topic. It's also worth noting, and this is huge, that all construction contracts or subcontracts related to an improvement are legally deemed amended to conform with these new legislative requirements. So the new rules apply even if your existing contract doesn't explicitly mention them. They essentially override any non-compliant clauses in older contracts.
That's a truly critical point, especially about contracts being automatically amended. You can't just ignore this. And thinking about that cascading payment structure, commentaries highlight a really important recommendation. How vital is it for contractors to include the full undisputed value of their subcontractors' work in their proper invoices to owners? It sounds like that's absolutely central to making this whole system function, like the linchpin.
It's not just important, it's absolutely crucial, the very linchpin, as you said. The entire prompt payment system, as designed, relies on the efficient and timely flow of money originating from the owner and cascading down through all tiers seamlessly. If a contractor doesn't include the full undisputed value of their subcontractor's work in the proper invoice they submit to the owner, it creates a potential bottleneck right at the very top of the payment chain.
Right, the money stops there.
Exactly. Even if the owner pays the contractor promptly, if the subcontractor's work was invoiced upstream by the contractor, their payment could still be significantly delayed, effectively breaking the prompt payment chain. So yes, it's not just highly recommended, but for the system to work as intended, there should ideally be an express obligation on the contractor, maybe even legislated in some views, to include all valid subcontractor work in their primary invoices. This ensures the payment cascades down efficiently and as intended by the legislation. It prevents an artificial break in the payment chain that the prompt payment regime is meticulously trying to eliminate.
Okay, so the prompt payment legislation is designed to get the money flowing consistently. But what happens when there's still a genuine disagreement about that money despite all these new rules? That's where statutory adjudication comes in, right? This is the companion mechanism, purpose-built for speed and efficiency in resolving disputes. Here's where it gets really interesting, because it's a completely different animal than traditional litigation.
Indeed. Statutory adjudication is truly a game changer for dispute resolution in Canadian construction because of its fundamental nature. It provides an interim, binding decision. Now let's unpack that. Interim means it's not necessarily the final word on the matter. It can still be subject to a final determination by a court or arbitration later on.
Okay, so not the absolute end of the road.
Potentially not, but binding means that the adjudicator's decision is immediately enforceable. Think of it like this. If you're a subcontractor owed money and the adjudicator rules in your favor, you get paid now, not years later after a lengthy court battle. The core idea, the true brilliance here, is to keep the money flowing and the project moving forward during a dispute, rather than having everything grind to a halt while legal arguments drag on. It's about ensuring projects don't stall over cash flow issues while the bigger arguments are sorted out later if necessary.
Get paid now, argue later if you have to.
That's a pretty good summary. And one of the most defining characteristics of adjudication is its compressed timelines. We're talking about decisions being rendered within highly compressed timeframes, usually around 30 days, maybe 45, with an extension agreed by the parties.
30 days, compared to years in court.
Exactly. It's light years faster than traditional litigation. It was designed to be a true fast-track process. And unlike a formal court proceeding, or even a lengthy arbitration, the process itself is generally much less formal. The adjudicator has considerable discretion over the procedures they follow, allowing them to tailor the process to the specific dispute and its urgency, rather than being bound by rigid court rules of evidence and procedure. It's meant to be pragmatic.
More flexible then?
Definitely. Now, regarding the scope of disputes that can be adjudicated, it's quite broad, yet very targeted. It's primarily designed to cover payment-related issues, which, as we discussed, are the most common cause of project friction and financial strain. So, for example, disputes over the valuation of services or materials provided. Payment claims, and this is key, including those related to change orders, whether they've been formally approved or not, or even proposed change orders where agreement hasn't been reached.
Change orders are a big one.
Huge. It also covers disputes arising directly from those notices of non-payment we talked about, arguments over amounts retained for holdbacks or set-offs, or even a refusal by an owner or consultant to certify substantial performance of the work. Parties can also agree to adjudicate any other matter they choose, but the primary focus is squarely on those issues that directly impact cash flow and project continuity.
So if I'm a listener thinking about my projects, what does this all mean? Does this cover absolutely every single dispute that could pop up on a construction site? If, say, a brand new crane accidentally knocks over a partially completed wall, would that go to adjudication? Or is it really just focused on the money side of things?
That's a really important clarifying question, and you've hit on the key distinction. While the scope is broad in terms of payment-related issues, it is indeed targeted compared to some international models that allow almost any dispute to be adjudicated. It's fundamentally not intended to cover every single type of dispute that could arise on a construction site. So no, if a crane knocks over a wall, that's likely a claim for damages, maybe a defect claim or a negligence claim. Those kinds of disputes, and others like significant construction defects unrelated to payment or personal injury claims, those would still generally go through the traditional court system or arbitration.
Okay, so it's not a catch-all.
Not at all. Adjudication's primary purpose is very specific, to facilitate cash flow and provide quick interim resolutions to disagreements that directly impact payments, ensuring the project's financial gears keep turning. The legislature's goal, remember, is prompt payment, and adjudication is the rapid-fire enforcement mechanism for that goal. It's not a wholesale replacement for all forms of dispute resolution. It's a scalpel, not a sledgehammer, designed for specific recurring payment ailments.
That distinction clarifies it perfectly. It's about keeping the financial pulse of the project strong. So with this incredibly fast-track system who is actually in charge of overseeing it, training the key players, and making these rapid interim decisions, let's shift our focus to the key players in the adjudication process, the authority overseeing it, and the adjudicators themselves. Who are these people?
Absolutely. In Canada, particularly in Ontario, which was the first out of the gate with this model, the province took a unique approach compared to some other international models that might have multiple nominating bodies. Ontario chose a single provincially authorized nominating authority, the Ontario Dispute Adjudication for Construction, or ODACC. You'll hear that acronym a lot.
ODACC.
This was a deliberate choice for quality control and consistency. ODACC plays a central and absolutely crucial role in the entire adjudication process. They're responsible for administering adjudications across the province, yes, but also for the vital tasks of training and qualifying adjudicators. They establish and maintain a publicly available registry of these qualified adjudicators, and critically, they appoint adjudicators when the parties involved in a dispute can't agree on one themselves within the tight timelines. Beyond these core functions, ODACC also sets competency standards for adjudicators, determines standard terms of appointment and fees, provides administrative support, develops educational materials for the industry, which is really important for uptake, manages complaints against adjudicators, and issues annual reports detailing the state of adjudication in Ontario. It's a comprehensive, cradle-to-grave oversight body designed to ensure the integrity and efficiency of the system.
Sounds like they have a lot on their plate.
They certainly do. And when it comes to the adjudicators themselves, there are very specific prescribed minimum qualifications. For example, in Ontario, adjudicators must have at least 10 years of relevant working experience directly in the construction industry. And this isn't limited to legal professionals. It's actually quite broad. It can include individuals with extensive backgrounds as accountants, architects, engineers, quantity surveyors, project managers, arbitrators, or lawyers, as long as they have that deep industry experience.
10 years in the trenches, basically.
Pretty much. And this practical, real-world industry experience is then rigorously coupled with successful completion of ODACC's specific training programs and certification. This deliberate emphasis on hands-on construction experience is a key distinguishing feature of the Canadian model, setting it apart from some other jurisdictions.
That's fascinating. I've heard that in some places, like maybe Ireland or the UK initially, adjudicators were almost exclusively barristers or solicitors, legal professionals. But what's truly fascinating here is that Canada seems to strongly emphasize hands-on construction experience. Why do you think that is? What specific qualities do you gain from that direct industry experience that makes for a truly capable adjudicator in this fast-paced environment?
That's an excellent point of contrast, and it really highlights a fundamental philosophical difference, I think. The emphasis on hands-on construction experience in Canada reflects a deliberate and very practical choice, prioritizing deep industry knowledge and commercial understanding. The thinking is that adjudicators who are dealing with these rapid cash flow critical disputes need to quickly grasp the nuances of construction projects, the technical terminology, the realities of site operations, the commercial pressures faced by contractors and subcontractors.
They need to speak the language.
Exactly. While legal acumen is undeniably valuable, the ability to intuitively understand how a project actually runs, what constitutes a valid delay on site, or how materials are properly valued in practice, often comes much more readily from direct boots-on-the-ground experience. You can't really get that just from a textbook. So a truly capable adjudicator needs a unique blend of qualities. They need excellent technical ability, meaning not just a knowledge of legal issues, but a profound understanding of the construction industry itself and its current developments. They also need strong procedural competence, being fully aware of the specific requirements and fast-paced nature of adjudication, and capable of managing an accelerated process. Crucially, strong case management skills are absolutely essential, as they have to steer the adjudication process through extremely tight deadlines, often dealing with complex factual scenarios in a very short period. And finally, robust writing skills are paramount, because their decisions, though interim, need to be clear, concise, and well-reasoned, even if they are brief, to provide immediate guidance and avoid further ambiguity. They need to be understood quickly.
Makes sense. Technical know-how, procedural smarts, management skills, and clear writing. Quite the package.
It is. And to further ensure the integrity and fairness of the process, ODACC also establishes a comprehensive adjudicator's code of conduct. This code covers critical areas such as avoiding conflicts of interest, which is vital in an industry where everyone seems to know everyone, ensuring proportionality in the conduct of adjudication, meaning the process and cost should always fit the size and complexity of the dispute.
Right, you don't want a sledgehammer for a nut.
Precisely. Promoting civility among all participants, maintaining strict procedural fairness for all parties, and upholding competence, integrity, and impartiality throughout the entire process. Adjudicators are strictly bound to adhere to this code, and it provides a clear framework for ethical conduct. As for the selection process for your specific dispute, it begins when the party initiating the adjudication names a proposed adjudicator, who must be chosen from that publicly available ODACC registry. This is the first step. If, for any reason, the parties can't agree on an adjudicator within 4 days, perhaps they each have different preferences or simply can't decide quickly enough.
Which probably happens a fair bit.
I'd imagine so. They can then request that ODACC nominate one for them. ODACC is mandated to do this swiftly, within 7 days. It's very important to note that, unlike some other jurisdictions or private dispute resolution clauses you might see, in Canada, the choice of an adjudicator cannot be predetermined or made a part of the underlying construction contract.
Oh, interesting. You can't bake it into the contract up front.
No. This ensures impartiality and prevents parties from being locked into an adjudicator who might not be suitable or perceived as impartial for a specific dispute that arises down the line. It ensures a fresh, fair selection for each new dispute.
That brings us nicely to the actual flow of an adjudication. This entire process is famously designed for speed, right? There's no time to waste. So walk us through the actual steps of an adjudication, highlighting that rapid pace. It sounds like a legal express train.
You're absolutely right. Speed is not just a feature. It's the defining characteristic of this process. It truly is a legal express train. The adjudication process is initiated by a written notice, which officially kicks things off. Once an adjudicator is appointed, the claimant, the party bringing the dispute, must serve their written adjudication claim, along with all supporting documents, on the respondent within, typically, 10 working days of the adjudicator's appointment. In Ontario, depending on the specific process chosen, the complete submission package might be due even faster, sometimes within just 4 to 5 days. It's quick.
Wow, 4 or 5 days to get everything together. That's intense.
It really is. The respondent then has a similarly compressed timeline, typically 10 working days, to serve a written adjudication response with their supporting documents. If no response is given within that time frame, the claimant can simply proceed with the adjudication without it. The adjudicator just moves forward. The claimant then usually has a final opportunity to provide a reply, often within 5 working days of receiving the response. As you can hear, every single step has a very tight deadline attached. No room for delay.
Very little wiggle room.
None, really. Now, while the adjudicator largely determines the specific procedures for the hearing itself, they must always adhere to the minimum procedures set out in the Act and its regulations. Contracts can also include additional procedures, but only if they don't conflict with these legislative requirements, which are paramount. To ensure proportionality for claims of varying dollar values, ODACC, the nominating authority, has established several predetermined adjudication processes. These are designed to fit the dispute. They range from a very lean 2-page written adjudication where submissions and photos are literally limited to just 2 pages each, ideal for simple, clear-cut payment disputes.
2 pages, that's incredibly concise.
Extremely, all the way up to an oral webcast adjudication, which allows for 10-page submissions, 25 pages of documents, and an oral presentation via video or teleconference for more complex matters. There's also a 5th option where the process is determined during an initial teleconference with the adjudicator, offering maximum flexibility. The critical point across all these predetermined processes is the absolute commitment to speed. They all aim for a final decision within 35 days of the adjudicator's appointment. That's the target.
35 days from start to finish. That's a world away from court.
A different universe, really. As for evidence and submissions, parties are generally expected to submit all documents they intend to rely on within 5 days of the initial notice of adjudication. Again, very fast. The scope of documentation should always be proportional to the dispute's value and complexity. You won't be submitting thousands of pages for a $10,000 claim, or at least you shouldn't be. Evidence can be made without excessive formality, a far cry from strict court rules of evidence. Adjudicators will issue directions for document disclosure to ensure each party has a fair opportunity to review what the other side is presenting. Given these incredibly tight timelines, most adjudications are conducted on a documents-only basis. Just makes sense.
So mostly paper-based.
Mostly. Oral hearings are quite rare. They're usually only permitted if absolutely essential, for instance, to clarify truly conflicting witness statements where credibility is key, or maybe to test expert reports where there's a significant factual dispute that cannot be resolved on paper alone. This focus on documents helps maintain that rapid pace. Another important feature, especially in complex projects with lots of parties, is the ability for consolidation of adjudications. If multiple adjudications involve the same or closely related matters, the parties can agree to consolidate them under a single adjudicator.
Makes sense. Avoids conflicting decisions.
Exactly. Prevents parallel, potentially contradictory decisions and streamlines the whole process. In Ontario, there's an additional powerful provision that allows a contractor to require consolidation, even if the parties don't initially agree, particularly if the disputes are clearly intertwined. This is a powerful tool for managing multi-party disagreements efficiently. Adjudicators also have provisions for resignation from a case. They can step down at any time if they determine that the matter isn't eligible for adjudication under the rules, or maybe if they feel they're no longer competent or able to continue, perhaps due to a conflict that arises mid-process. In such cases, they must promptly notify the parties. Conversely, the parties themselves can agree to terminate an adjudication at any point before determination is made, Perhaps they reach a settlement, though this is usually subject to paying the adjudicator's fees for the work done up to that point.
So you can still settle midstream.
Absolutely. The door is always open for settlement. Confidentiality is also built into the process. Generally, the adjudicator and the parties involved cannot disclose information from the adjudication unless it's strictly necessary for the enforcement of the decision later on, or if explicit consent for disclosure is given by everyone. This helps foster an open, candid discussion during the process, without fear that every piece of information will become public fodder. Finally, let's talk about costs. This is always a big question. Generally, in an adjudication, parties are expected to bear their own legal costs, preparing their submissions, getting advice, etc., and they split the adjudicator's fees equally, 50-50. This promotes access to the system, keeps it relatively affordable compared to court.
Okay, so you pay your own way and split the judge's fee, basically.
That's the default. However, there's an important exception designed to deter bad faith conduct. If an adjudicator determines that a party has acted in a frivolous, vexatious, and abusive process, or other than in good faith manner, for instance, just dragging out the process without merit, making baseless claims.
Playing games.
Exactly. The adjudicator may order that party to pay some or all of the other party's legal costs, or even the adjudicator's own fee that would otherwise be shared. This acts as a powerful deterrent against engaging in dilatory or dishonest tactics. ODACC also provides suggested hourly rates for adjudicators to guide the fee structure, ensuring transparency and predictability on that front.
So we've walked through the rapid-fire process, which sounds incredibly efficient, almost dizzyingly so. Now, after the adjudicator makes their determination, what happens next? How quickly does that decision take effect, and what are its immediate and long-term implications for you and your project?
Right, the decision itself. Once the adjudication process concludes, the adjudicator must render a written, reasoned determination within 30 days of receiving all the claimant's documents. That's the standard, extremely strict statutory deadline. That deadline can be extended by 14 days if the adjudicator requests it and both parties provide their written consent, or for a longer agreed-upon period with the adjudicator's consent. But, and this is absolutely crucial for any party relying on the process, a determination made after this deadline has no force or effect. If the adjudicator misses the deadline, the decision is essentially invalid. Poof, gone.
No pressure on the adjudicator, then.
Exactly. It ensures adjudicators feel the same pressure for speed as the parties. The adjudicator is required to provide an electronic copy of the decision on the very day it's made, ensuring immediate communication, and then a certified paper copy within 5 days. They can also correct any simple typos or clerical errors within 7 days. Now, the nature of the determination, it's what we call interim binding. This means it's binding on the parties until a final determination of the matter is made by a court through an arbitration or by a written agreement between the parties settling it definitively.
Interim binding. Okay.
The Act explicitly clarifies that it doesn't prevent a party from commencing court or arbitration proceedings to finally determine the matter later on. Its primary purpose is simply to ensure money keeps flowing in the interim, allowing projects to continue and businesses to remain solvent, even while any deeper, more complex disputes might still be resolved through traditional, slower means if necessary.
So it resolves the immediate cash crisis, but maybe not the underlying argument permanently.
That's a good way to put it. Imagine being a small subcontractor, owed $50,000 for work completed months ago. This interim binding decision means you can potentially get that money in weeks, not years, preventing your business from potentially collapsing while the lawyers argue the bigger picture later. And a key aspect of this regime is the exceptional enforceability of these interim decisions. Adjudicators' determinations are enforceable as if they were actual orders of the court. This is highly significant. It means there's no need to go through another lengthy court process just to get a judgment based on the determination. The determination itself, once issued, is treated akin to a court judgment, albeit a temporary one.
So you take the adjudicator's paper straight to enforcement.
Pretty much. A party can simply file a certified copy of the determination with the court for enforcement purposes, and this can be done within 2 years of the decision being communicated or after any final judicial review. This is a streamlined path to collection, designed to cut through bureaucratic delays. The legislation also provides potent, immediate remedies for non-payment of adjudicated amounts. This is where the real teeth are. If the adjudicated amount is not paid within 10 days of the determination being communicated.
Just 10 days to pay up.
Yes. The unpaid party gains significant contractually protected rights. First, they can suspend or reduce the rate of performance of construction work. And crucially, this action is explicitly not considered a breach of contract.
Wow, so you can stop work without getting sued for breach.
Exactly, that's a major protection. This means they cannot be sued for breach of contract, simply for stopping work when they aren't paid according to the adjudicated decision. The party is also legally entitled to a fair and reasonable extension of time to complete their obligations and can recover any losses and expenses incurred due to the suspension, such as demobilization and remobilization costs. This is a huge leverage point for unpaid parties. Second, and this is a powerful mechanism, particularly for subcontractors down the chain, if the party ordered to pay fails to do so, the winning party can make a written request for direct payment from the principal.
Go straight to the source of the money, like the owner.
Precisely. For example, the owner, if the main contractor hasn't paid a sub after an adjudication, the principal must then notify the non-paying party. And if proof of payment isn't provided within a set time frame, the principal must pay the adjudicated amount directly to the winning party. The principal can then recover this amount from any money they owe to the non-paying party further up the chain, for example, by deducting it from the next payment to the main contractor. This ensures the payment cascades down the tiers, bypassing non-compliant parties.
That's a clever way to ensure the money gets where it's supposed to go.
It is, and importantly, parties can exercise any or all available remedies concurrently to enforce the decision. They aren't forced to choose just one, maximizing their chances of quick recovery. They can suspend work and seek direct payment, for example. Now, the adjudicator's determination and their reasons for the decision are admissible as evidence in court. This brings up an interesting and somewhat controversial point in the legal community.
Okay, so the decision can be used in court, and that makes sense for context, but why is there a concern that it might have significant influence over future proceedings, even though it's explicitly interim? It sounds like it could inadvertently create a sort of de facto appeal if judges or arbitrators give too much weight to it. That feels like a subtle but very important tension.
You've articulated the tension perfectly, and it's precisely the concern that legal commentaries have raised. While the legislative intent is crystal clear, these interim decisions are not meant to be binding for final determination, and judges or arbitrators should conduct a fresh, independent review of the merits. There's a practical fear. The fear is that courts or arbitral tribunals might give undue deference to the adjudicator's reasoning, perhaps subconsciously, given the perceived expertise of the adjudicator, often industry experts, remember, and the interim binding nature of the decision.
They might think, well, the expert adjudicator already looked at this.
Exactly.
Yeah.
This could, in effect, inadvertently turn what is meant to be a new independent hearing into something that feels more like an appeal of the original adjudication award, where the court is reluctant to overturn the adjudicator's findings unless there's a very clear, obvious error. This is absolutely not the legislature's intention. The goal is simply to get money flowing quickly, not to prejudge the final outcome. Commentary strongly suggests that future legislation or maybe court guidance should explicitly clarify this point, emphasize that deference is not to be given to the adjudicator's determination in final proceedings. This would maintain the integrity and purpose of the full court or arbitration process as the place for the final definitive answer.
So keep the interim step truly interim.
Precisely. On a related note, while an adjudicator's past determinations aren't legally binding precedent like court decisions are, establishing a public database of these decisions, may be anonymized, could still offer valuable guidance. It would allow for the gradual development of thematic understanding within the industry on how common issues are being addressed, without setting strict precedents. It's about building a body of practical knowledge over time, helping everyone understand how the system works in practice.
That makes perfect sense for learning and consistency within the industry. So, given how quickly these decisions are made and their interim binding nature, what are the avenues for challenging an adjudicator's determination? Can you just appeal it like a regular court decision if you think they got it wrong? Or are the grounds for challenge much more limited?
That's a critical point to grasp. Judicial review is the primary mechanism for challenging an adjudicator's determination, but it is absolutely not an appeal on the merits of the decision. This is a fundamental distinction. You cannot challenge an adjudicator's decision simply because you disagree with their conclusion on the facts or even their interpretation of the law, as long as they acted within their jurisdiction and followed proper procedure.
So you can't argue they just got the answer wrong.
Generally, no. The grounds for setting aside an adjudicator's determination are very specific and incredibly narrow. They largely mirror the limited grounds on which commercial arbitral awards can be challenged, and for good reason. To preserve the speed and finality, even if interim finality of the decision. Delaying payment through endless appeals defeats the whole purpose. These statutory grounds or the adjudication was conducted by someone other than a qualified adjudicator from the approved registry. Or, critically, the procedures followed did not comply with the Act or regulations, indicating a fundamental lack of procedural fairness. Maybe one side wasn't allowed to present their case properly. Also, if there was a reasonable apprehension of bias on the part of the adjudicator, which would taint the impartiality of the decision, or if the determination was made as a direct result of fraud. Some provinces, like Saskatchewan and Manitoba, may include additional specific factors for the court to consider, such as the specific documents the adjudicator reviewed, but the overarching focus remains squarely on the integrity of the process rather than a reevaluation of the facts or the law applied.
So it's really about fair play in action, making sure you had a fair opportunity to be heard and that the process was sound, rather than whether the adjudicator made the right decision on the facts. It sounds like a strong emphasis on principles of natural justice.
Precisely. You've hit on the core principle. The judicial review focuses squarely on adherence to fundamental principles of natural justice and procedural fairness. It's about ensuring impartiality, making sure that each party was treated equally and had a fair opportunity to present their case, to correct or contradict any statements prejudicial to their views, and, crucially, that the adjudicator acted within their statutory jurisdiction. The court isn't there to second-guess the adjudicator's factual findings or legal interpretations. It's not about relitigating the substance of the dispute or reevaluating the evidence to see if the adjudicator made the right call on the facts.
They're checking the referee, not replaying the game.
That's a great analogy. The court's role is simply to ensure the process itself was fair and in accordance with the law, not to substitute its own judgment for the adjudicators on the merits of the dispute. This strict limitation is what ensures the speed and interim enforceability of the adjudication. In Ontario, there's an additional significant hurdle. Parties must seek leave or permission from the divisional court to even bring an application for judicial review. This isn't an automatic right.
You need permission just to ask for a review.
Yes. And this motion for leave can be dismissed without reasons, and there is no appeal from the denial of leave, making it a very powerful gatekeeping mechanism. Furthermore, this application for leave must be filed no later than 30 days after the adjudicator's determination is communicated. That is an extremely tight deadline, particularly given the legal complexities potentially involved in arguing procedural unfairness or bias.
30 days, wow. They really want to discourage challenges.
They want to discourage challenges used purely for delay. Absolutely. And here's a truly critical point to understand. Seeking leave for judicial review does not automatically stay a party's payment obligations under the adjudication decision, unless the divisional court specifically orders otherwise.
So you still have to pay up even while you're trying to challenge the decision?
Generally, yes. This directly reinforces the legislature's primary goal of prompt payment, not just prompt adjudication. In practice, courts often require payment of the adjudicated amount into court as a condition for even allowing a stay motion or leave motion to proceed. This ensures that even if there's a challenge, the adjudicated funds are secured and not simply withheld indefinitely, maintaining the pressure for cash flow.
I can see that this really puts teeth into the prompt payment aspect. You mentioned one of the grounds for judicial review being the contract or subcontract has ceased to exist. Commentaries highlight a specific challenge with this phrase in construction. What makes this wording problematic in an industry where things like warranties can last years beyond project completion? It seems like it could create an unexpected loophole.
That phrase, the contract or subcontract, has ceased to exist, indeed presents a significant and somewhat problematic ambiguity, particularly in the context of construction. Construction contracts are often incredibly complex documents. They're not just about building something. They contain numerous provisions, such as warranty obligations, indemnities, maybe ongoing maintenance clauses, that are explicitly designed to survive the physical completion of the work for many years, sometimes even decades. Think about a 10-year warranty on a roof.
Right. The contract isn't really over just because the building is up.
Exactly. So determining precisely when a contract has truly ceased to exist for the purpose of adjudication becomes very difficult to pin down. This ambiguity might inadvertently prevent adjudication for payment disputes that arise later in a project's life cycle, for instance, related to a payment holdback tied to a warranty claim for faulty work, even if it's fundamentally a payment-related issue. Commentaries have recommended that future legislation clarify this wording. Perhaps it should refer to when the contract's primary performance obligations related to the construction itself have concluded, rather than when all possible long-term liabilities have expired. This would avoid unnecessary exclusions from the adjudication process and ensure that the regime maintains its broad applicability for payment disputes throughout the reasonable life of a construction project and its follow-on obligations.
Needs a bit of fine-tuning, perhaps.
Potentially, yes. Finally, it's worth noting that if an adjudicator's determination is successfully set aside on judicial review due to one of these limited procedural grounds, parties are generally prohibited from initiating another adjudication for the very same matter. The idea is to move towards a final resolution, either through the courts or arbitration, once the adjudication process has run its course and been found procedurally deficient. It prevents endless cycling through adjudication for the same dispute. You get one fair shot at the quick process.
Okay, that makes sense. So, while Ontario has really been a trailblazer and a leader in implementing this, how is this prompt payment and adjudication regime rolling out across the rest of Canada? Is it a uniform picture, or are there significant nuances from province to province that listeners need to be aware of, especially if they work across borders?
It's definitely a mosaic across Canada, rather than a perfectly uniform picture, though there are strong underlying similarities reflecting that common policy objective. We discussed better cash flow, faster dispute resolution. Prompt payment legislation, often coupled with adjudication, is currently fully in force in Ontario, Saskatchewan, and Alberta, with Alberta's legislation, for example, coming into force back in August 2022. New Brunswick also has its Construction Remedies Act in force since November 2021, which includes prompt payment timelines at adjudication. At the federal level, there's also legislation with prompt payment and adjudication mechanisms in place for certain federal projects, like those governed by Public Works and Government Services Canada. So federal jobs have their own similar system.
So, Ontario, Sask, Alberta, New Brunswick, and federal are live. What about the others?
Right. Looking across the rest of the country, several other provinces have legislation either underway or actively contemplating it. Nova Scotia's Bill 119, for instance, has received royal assent, meaning it's officially law for prompt payment, proper invoices, and adjudication. But it's not yet in force. The government hasn't proclaimed it yet. And notably, it doesn't include specific transition provisions for old contracts, which means it could apply retroactively once enacted, which is something to watch.
Okay, Nova Scotia's waiting in the wings.
Exactly. British Columbia introduced Bill M223, which focuses on prompt payment deadlines and proper invoices, but, and this is a significant difference, it currently does not provide for an adjudication process. So BC is going for prompt payment without the rapid dispute resolution piece, relying solely on the payment timelines.
Interesting. And just the payment deadlines?
Yes. Manitoba has a Private Members Bill 245 proposing prompt payment, proper invoices, and an optional, fairly minimalistic adjudication process, though the specific regulations needed to make that work are still to be drafted and finalized. So Manitoba is exploring it, but details are sparse, and both New Brunswick, which already has a system, and Quebec have been actively investigating prompt payment further as a potential future policy or refining existing approaches, recognizing the benefits seen in other jurisdictions. So the trend is definitely towards adoption.
So a definite trend, but with variations.
Absolutely. While there are strong similarities in the overall framework, the proper invoice trigger, the cascading timelines, the idea of interim adjudication, important nuances do exist across these provincial regimes. For example, in terms of the scope of exemptions, provinces like Alberta and Saskatchewan have broader exemptions in their application, meaning certain types of projects or maybe certain public sector entities might not be covered, whereas Ontario's framework is generally broader in its applicability. Commentaries widely suggest that a broadly applicable framework is generally more effective in truly addressing industry-wide payment issues. Fewer loopholes is better, basically. Generally, yes. There are also subtle differences in the precise wording and requirements for a proper invoice and the rules around their revision, as we discussed earlier. Those little differences can create practical hurdles for contractors working across provincial borders. You need to know the specific rules for each province. And it's important to remember that in some jurisdictions, like New Brunswick, even though it's live, Manitoba, Nova Scotia, and federally, the specific regulations pertaining to adjudication are still being finalized or potentially revised. So some of the detailed procedures, criteria, maybe adjudicator fees, are yet to be fully defined or could change. This means the system is still evolving in real time in some parts of Canada. It's a dynamic landscape. So keep an eye on the regulations in your specific province. Definitely. Despite these provincial variations and ongoing refinements, these reforms collectively represent a fundamental and really significant shift in how cash flow is managed and how disputes are resolved across the entire Canadian construction industry. The overarching goal is clear: to achieve more efficient, more predictable, and more cost-effective outcomes across a wide range of industry sectors, from large-scale industrial projects and public buildings to residential developments and major transportation infrastructure. It's a concerted move towards a more modern, financially stable, and ultimately fairer construction landscape for everyone involved, from the largest owner down to the smallest subcontractor.
So, what does all of this mean for you as a listener navigating this increasingly complex landscape? The Canadian construction industry is rapidly evolving with these new prompt payment and statutory adjudication regimes. They're aiming to address those long-standing, often crippling cash flow issues and provide truly faster, more interim dispute resolution. It's a foundational move towards greater efficiency, transparency, and hopefully fairness for everyone involved, from the top of the pyramid to the very base. As you step into or continue to operate within this new landscape, maybe consider how these changes might not just affect legal compliance checking the boxes, but fundamentally reshape collaborative practices and risk management on Canadian construction projects. This isn't just about new rules. It feels like it's about pushing the entire industry towards more proactive problem solving, maybe fostering stronger stakeholder relationships, and perhaps even building more trust between parties because the payment risks are somewhat mitigated. What implications might this profound shift have for your projects, perhaps 5, 10 years down the line, as these systems mature and become even more ingrained in the way we do business in construction? Something to think about. Before you go, please don't forget to share, like, or subscribe. Also, have a look at other episodes and visit CM Guide website for better insights on this topic.